Okay, welcome everyone. Please let me know if you hear me okay. All right, so I won't take too long here. I'm going to say hello. Everyone who's watching, please join the chat. Enjoy the chat. The chat is for you. Uh, Make yourself at home in the chat. Welcome in to Carol, to Bobby, and to Pam, and anyone else. Welcome on in. I'm not going to take too long to get started because I don't want to be here long. Uh, I'm coming in to finalize reading the last three documents I want to cover. What's up, Fur Baby Daddy? I'm going to read these last three motions filings for you, and then we'll adjourn until later tonight for our Friday night show. Welcome in, Marianne Foster. I have lots of thoughts, and who knows? We'll get to them in time, but let me jump on into the documents and get that out of the way. And everyone enjoy the chat and welcome in. And if you're on the replay, enjoy the comment section. But as you know, yesterday wrapped up the third day of the hearings for Richard Allen, and there was lots disclosed yesterday. And the interesting thing here, before I get started, I guess I'll say this, is that I don't talk about it often, but I monitor. Not only do I monitor all the discords, I monitor all the Reddits, and I also monitor all the Twitters and the Facebooks. And so on the Facebook groups, it's just been so interesting how stupid people are. I mean, because we all saw the same thing yesterday and the past 3 days. Okay, with these hearings, and it's just funny how everyone is in their own fantasy world and wants to run and interpret the data as they see fit in a way that will confirm their own biases and prejudices and opinions. And so I've seen all kind of idiots and assholes running around the YouTubes. I'm sorry, the Facebook groups, giving their own spin on what was disclosed. And tell you, it's all extremes, and I don't understand you people with the extremes. I mean, I'm not even going to lay out any details or any thoughts, but all I will say is that lots of little tidbits did come out in the 3 days of hearings, and it's just absolutely hilarious. I mean, I know that we're dealing with a bunch of retards. Okay, uh, Central Indiana, these people who are covering this and interested in the Delphi murders. I equated it to a bunch of maggots or a bad case of lice. I mean, most of the people are completely fucking psychotic. Uh, uh, they are not very well educated. They basically, I call them retards, or they're just criminally insane and covering for their own uh, involvement in some way in this situation, because the interpretations that I've seen of basic facts, that basic nuggets that came out in these hearings, and the way people wildly ran with them is unbelievable, confirming their own biases, prejudices, and prior opinions to make themselves seem right, and it's amazing. Uh, like I said, I'm not even going to get into any examples, and I'm not going to call the names, but I will say this: I will be calling names very soon. You see, I've tried for the longest to ignore the dumbasses and and the douchebags and those threatening. Uh, I've tried to just ignore them, but that hasn't worked because they continue, and so they will be addressed, especially the absolute snakes. A lot of these snakes are women, and see, it's bad because they use that because if you criticize them being a woman, then the first thing that them and all their buddies are going to say is, you attack women. Okay, when it's just the case that no, I respond to assholes. Okay, so the fact that you're responding to women being assholes, they're going to cast as you attack women. But it's going to happen because of the shit that is occurring and has occurred. It's unbelievable. And a bunch of you stank bitches, you're going to pay. Not only that, everyone will pay. Um, like I said, I've tried my best to ignore all you idiots, and you want to continue. So here's the price you will pay. Uh, See, this Delphi murders thing will go away. It will. Eventually, it will go away. But you know what won't go away? The memory of what you've done uh, to me and my family and the people that I care about in the process. And don't think that you'll get away with it, because when you see uh, the next several years of clapback that you're going to receive for the things you've done, don't be mad at me. Okay. And anyway, I'll leave it at that. All right. So, first thing we're going to look at is this one here. State's request for pretrial ruling on admissibility. Comes now the state of Indiana request a pretrial ruling as to the admissibility of certain communications made by Richard Allen to a psychologist. In support of this request, the state submits the following: that Richard Allen has access to mental health services at the Indiana DOC, where he has been housed for safekeeping pursuant to court order. That mental health personnel employed by Centurion Health provided psychologists and counselors to whom Richard Allen has made statements. That in particular, Dr. Monica Walla, a psychologist licensed to practice in the state of Indiana, has documented statements of Richard Allen, which the state believes fall within an exception to confidentiality. Indiana Code 2533117, privileged communications between psychologists and clients, states in part, quote, a psychologist licensed under this article may not disclose any information acquired from persons with whom the psychologist has dealt with in a professional capacity, except under the following circumstances: trials for homicide, when the disclosure relates directly to the fact or immediate circumstances of said homicide. The state intends to offer into evidence the testimony of Dr. Monica Walla, as documented in her reports entitled DOC Behavioral Health Suicide Observation. State seeks this ruling for the sole purpose of expediting the presentation of evidence during trial and put the defendant on notice as to evidentiary exception and obtain a pretrial ruling on admissibility. Remember also, she's destroyed all her notes. Now, let's take a detour. Let's take a little detour. Just one moment, please. Hey. Let's see if that's working. You may notice that 2 months ago, I was up in arms over this. Wait, what happened to all the troll farm posts about this not being Dr. Monica Walla? Sus as fuck. Okay? I'd like you to notice this. Okay, you can't, I'm sure you can't read these very well. Okay, so I'll read them for you. And I may even read them in order, okay? So that you understand why we are all upset here. Okay. For instance, Um, 1, 2, 3, 4, 5, 6, 7, 8, 9. Delphi After Dark, Delphi Murders Uncensored, Delphi Murders Let's Chat, Delphi Down the Hill, Defense Diaries, and these two I can't make out. Delphi Murders Case Discussion. This one I can't make out. Do you see? Okay. Do you think this is appropriate for Dr. Monica Walla? Delphi Murders, Drama, Gossip, and Facts. Anyone think it's super inappropriate for a treating psychologist who may be a witness at trial, is a member of this group and others? Super inappropriate, isn't it? Just wondering who everyone watches on YouTube. I'm not here to argue. We all like different people. Personally, I prefer channels that don't just follow the narrative and do their own research. Do I agree with everything they say? No, but I respect their opinions. The channels I don't watch are the ones that yell and call people names because they don't agree with them or question them. They have egos that can't allow them to be wrong. Okay? Monica Walla, the Monica Walla. Gray Hughes, Delphi After Dark for the drama. See? Delphi After Dark for the drama. See the others? Greeno, Teresa, Bob Mata, Douche Sleuth crew. His calm tone is unnerving. So, what do you get from this woman here? What do you get from this response? Immaturity? Entertainment? It's all a game? Delphi After Dark for the drama? Really? Because it's a game, it's entertainment? And you're treating, back to this, you're treating Mr. Richard Allen and you may be a witness at trial? Then I'd like to introduce you to this cunt. Please help spread the word. The conspiracy theorists, that's us, are at it again. There is a full cross-platform spread of misinformation like wildfire on Facebook, YouTube, Reddit, and X. This woman did not deserve this. This pertains to the filing by McClellan yesterday regarding psychologist Dr. Monica Walla, and several threads on Reddit, and a YouTube live performed by Angela from the defense witness list for contempt hearing. This poor woman has the unfortunate circumstance of having the same name as Dr. Walla and being interested in the Delphi case. This is not Dr. Monica Walla. If you see someone harassing or doxing this woman on these platforms, please ask them to stop. Okay? This is not. Please help spread the word. This is out of control. I don't know what is wrong with people, says this cunt here. Okay, do you see the troll farm at work? Do you understand the narrative pushing going on here? I didn't make this post. Coincidentally, this post and all the others like it by this person and the other troll farm members who spread this post, it disappeared magically without a single retraction, without a single correction, without a single word. It just suddenly vaporized into the ethers when they realized you can't because we already knew. Okay, this one. Yes, you see, Delphi After Dark for the drama. So you think this is okay? No words. All right, so here we're going to read through defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Comes now Richard Allen through attorneys pursuant to the 5th, 6th, 14th Amendments to the Constitution, Article 1, Section 12, Indiana Constitution, and Indiana Code 3534 14A 11. Moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence. Okay? In violation of Brady standards. The accused states the following. On February 7, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. In his first motion, the defense detailed how a February 17, 2017 interview of third-party suspect Holder was destroyed while in possession of law enforcement, along with multiple days of other interviews. Yes, the entire first week. On March 18, a hearing was held on the matter. At the March 18 hearing, Steve Mullen, who failed to follow up on Tyler Carpenter and his alleged role in the crime scene photos leaks and his alleged purchase of crime scene photos from Mark Robert Cohen, that Steve Mullen testified that other evidence was destroyed in 2017 as well, as it was purportedly unintentionally taped over. Furthermore, at said March 18, 2024 hearing, which we've gone through in full and you can find on the channel, we read through all the transcripts of that in detail. The defense tendered Mullen's updated reports that purportedly explained how the evidence was destroyed. The prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from prosecution. On April 2nd, 2024, the court issued its ruling denying the defense motion to dismiss charges. Since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and or potentially useful evidence that the prosecution has not turned over to the defense, is missing, or that the state of Indiana has destroyed. Just like Allen's first motion to dismiss, the missing and destroyed evidence relates to third-party suspect Brad Holder. During a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned over his phone to law enforcement on February 17, 2017. Prosecution has not turned over any data, extractions, reports, or other evidence from Brad Holder's phone. Curiously, on the same day and at the same time, Holder believes that he turned his phone over to law enforcement officers. His son also turned over his phone. Prosecution has turned over data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone, because there was none, allegedly, extracted. As unbelievable as that may sound. While the data from Logan Holder's phone was extracted, law enforcement apparently claimed that they failed to extract data from Brad Holder's phone, even though both he and his son turned over their phones to law enforcement at the same time. Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. When asked if he would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Depends on the circumstances, but I think you'd have to ask the FBI what they did, because Holman will never give you a straight answer. Finally, After being pushed by the defense, Holman finally conceded that he would have extracted the data from Holder's phone if given the opportunity. Well, you had the opportunity. The defense find it highly, highly unlikely that law enforcement would take time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at the time, and no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. Yeah, don't you find that interesting? On February 17, 2017, documents specifically sought out by the defense, Doug Carter's emails with the FBI, provided evidence that A. Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Holder interviewed at the Delphi police station and turned over his phone to law enforcement. B. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C. Even top FBI agent in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D. Logan Holder was not mentioned as a suspect in these emails. 20. This begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phones, but only extract data from Logan Holder's phone when he was not a suspect, but would not extract any data from Brad Holder's phone when he was a suspect? 21. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other fucking phones, which seemingly have little or nothing to do with the murders. Yeah, but oddly enough, they don't have the family's phone extractions. This begs another question. Why would law enforcement take the time to extract data from 101 phones and not the family's phones, which would be necessary to formulate a specific timeline, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17, 2017, and he was a suspect at the time? Makes a lot of sense, right? Why would they not extract the family's phones in order to corroborate their story and nail down a timeline, including time and place, and establish the veracity of their claims about what happened before, during, and after the time the girls were allegedly placed on Ron Logan's property? 24. Logic and common sense support this belief. 25. If any law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept. All evidence of Brad Holder's second interview with law enforcement is missing. Yes, just like the phone extraction. That never happened. Additionally, Brad Holder testified in his deposition that in addition to law enforcement's February 17, 2017 interview, which was purportedly accidentally taped over, that law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. Holder further stated or testified at his deposition that A, law enforcement conducted the second interview at the Logansport police station. More on Logansport later, especially in reference to the McClellan and Long family. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. D, the interview involved much questioning about Patrick Westfall. We heard some of that this week as well. 28. After the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone because they allegedly didn't perform one, and B, no evidence whatsoever in the form of video, audio reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport police station. More on Logansport will be forthcoming. On May 13th, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport PD and have no record of Brad Holder's phone being downloaded because it wasn't done according to law enforcement, even though he was a suspect. At a recent deposition, when Unified Command's Jerry Holman, remember, Unified Command needs to be replaced with Unified Cover-Up, was asked about how the defense could obtain any information about the second interview, Holman said he had no idea because he always plays dumb. But he encouraged the defense to reach out to Logansport PD to find out. Passing the buck, shirking responsibility and accountability, Jerry Holman. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is a requirement of law enforcement. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he met Abigail Williams, victim. Let's repeat that. At said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he had actually met victim Abigail Williams. 2 times. And that one of his meetings with Abby took place at Patrick Westfall's house. When Jerry Holman was confronted with Brad Holder's ever-changing stories concerning how many times he met Abby Williams in actuality, Holman stated, "Perfectly reasonable, in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't see exactly what you're asking me." Yeah, right. So why was Holman promoted? Why was Shane Evans promoted? Why was Nick McClellan promoted? Why has everyone been propped up in this Delphi murders scam, cover-up, farce of an investigation? When Holman was asked if it were likely that Brad Holder would not remember meeting Abby, when Holder was asked 3 days after the murders at his February 17th, 2017 interview, but then 7 years later he would remember meeting Abby twice, Holman responded, "Possibly, yeah." Holman showed no curiosity nor interest whatsoever about why Holder's story has changed. This attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. Patrick Westfall was interviewed on August 17, 2024. Well, that's going to be 2023. And law enforcement was extracted from Westfall's phone. All right. The phone extractions show that Westfall's phone had no data prior to August 11, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. So you see what happened? Let's go back to 36. Patrick Westfall was interviewed on August 17, 2023, and law enforcement extracted data from his phone. The phone extraction shows that Westfall's phone had no data prior to August 11th, which was the same day that law enforcement contacted him and asked him to come in to be interviewed a week later. Nothing to see here? In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westfall's phone was between August 11th, 2023, which was on or about when police contacted him, and August 17th, 2023, which was when he was interviewed. No text, videos, photographs, emails, or any other data existed on Westfall's phone before the day that police contacted him on August 11th, 2023. When Jerry Holman was confronted with the fact that Patrick Westfall likely attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, "People erase things all the time." Later, Holman stated that he found nothing suspicious about Patrick Westfall concealing his phone data before his August 17th, 2023 interview. Does no one see this obvious apathy coming from Jerry Holman? It's apathetic almost to the point of obviously covering the ass of Holder and Westfall. Do you not see that? So he sees nothing odd about Holder lying about how many times he met Abby. He sees nothing odd about Westfall deleting the entire contents of the phone the day he's contacted by law enforcement to come in for an interview a week later. Again, Holman's attitude toward third-party suspects, Holder and Westfall, supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith or have intentionally not provided missing evidence such as Brad Holder's second interview as well as other items identified in this motion. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Holder if he would allow state police to extract data from his phone, even though it's clear that Holder had brought his phone with him to the interview. So let's see. Even though Holder was a suspect, ISP was never interested in extracting his phone. How does that make sense? Therefore, it is not known whether Holder similarly hid or erased data from his phone like it appears Westfall has done. But it certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. It's also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. I don't know about you, but I've lost faith in ISP completely. Lost faith in Doug Carter. I've lost faith in David Vito. I've lost faith in Jerry Holman. I've lost faith in Brian Harshman. It is also curious as to why David Vito failed to ask Brad Holder one single question as to the incriminating statements that Amber Holder attributed to Brad Holder that are detailed in the Franks 1. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense contention that law enforcement is acting in bad faith, i.e. corrupt. In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over first interview from February 17, 2017, another key piece of evidence is also missing. The mimicked crime scene photo that was on Brad Holder's social media Facebook page. Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in spring of 2017. This image was marked as Exhibit F in Purdy's deposition and discussed on pages 79 to 81. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. In the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged, lying on the ground in the woods with branches laid across their bodies. One of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged, positioned in a similar manner as one of the victim's hands were staged, positioned in this case. At the time that Trooper Purdy observed the mimicked crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene, the positioning of the bodies on the ground in the woods, or that branches and sticks were arranged on the bodies. In the April 12, 2017 report from Trooper Ryan Winters, it was learned that state police also came into a possession of said mimicked crime scene image through an internet sleuth named Ryan Boucher. Boucher alerted Winters to the disconcerting images on Brad Holder's social media page and sent said images to Trooper Winters over the internet. On April 12, 2017, Trooper Winters then shared with Jerry Holman his knowledge of the mimicked crime scene images found on Holder's social media pages and the other information. Because of the similarities between the images that Boucher sent Trooper Winters from Brad Holder's social media and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. Despite that request, the Indiana State Police ignored Trooper Winters and never re-interviewed Brad Holder. Are you seeing a pattern here? Brad Holder was only interviewed in August 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. To this day, prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. Fortunately, because internet sleuth Boucher had saved the image that he had turned over to Trooper Winters, the defense team was able to drive to Georgia and retrieve that image. When deposed, Trooper Winters claimed that the Indiana State Police could not access the images that Boucher found on Holder's social media that he then turned over to state police. How could the Indiana State Police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? Remember, Holder was a suspect. The photo did loosely mimic the crime scene. State Police gave zero shits. The defense again would proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence from a suspect would not be lost by Indiana State Police. The defense is filing simultaneously herewith its memorandum in support of second motion to dismiss, based upon newly discovered, destroyed, and or missing exculpatory evidence. Okay? As detailed in said memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following: video of Brad Holder's first interview from February 17, video of Logan's interview from February 17, data from Brad Holder's phone extraction from February 17, which doesn't exist, video from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 17 or 2018, audio from Brad Holder's second interview with law enforcement taken at the Logansport police station, any reports or notes or documents concerning or referring to Brad Holder's second interview at the Logansport police station, Mimicked crime scene photo observed by Trooper Purdy on Brad Holder's social media page. Images Ryan Boucher sent to Trooper Winters on April 12, 2017. Notice that all the missing items are related to third-party suspect Brad Holder. Also note that the prosecution is asking that the defense not be allowed to even mention the name Brad Holder during trial. Remember, we read over that yesterday. Okay, they don't want the name Brad Holder to be mentioned or anything else from the Franks memorandum or the Todd Click report or Keegan or Tony Klein. Currently, the list of evidence, or Ron Logan. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution turn it over, or until the prosecution realization that defense would soon be learning about the existence of said evidence, includes A, Todd Click letter and accompanying 85-page report, multiple Elvis Fields interviews, Rod Abrams interviews, multiple Johnny Messer interviews, multiple Taylor Hornady interviews, Ned Smith interview, Liberty German phone dump. Notice that all items A through G in paragraph 69 are related to third-party suspects and Odinism. Also note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. Remember, the evidence that the defense does have in its possession showcases on multiple occasions third-party suspect Brad Holder has changed his answer concerning the very basic question of how many times he has met Abigail Williams. According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he never met Abby Williams. At the time he was first approached by law enforcement and asked that question, how many times did you meet Abby Williams? Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity and time that Brad Holder's son dated Abby Williams. Logan Holder was dating her at the time of the murders. And B, the enormity of the situation. That is, the two girls had just been murdered, one of whom had dated his son. If Brad Holder in any way was involved in the murders, then Brad Holder's claim that he never met Abby Williams is understandable. Denying that he had ever met Abby Williams could, in his mind at least, cause the police to take their attention off of Holder. If at his February 17, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to the police when asked the same question even 6.5 years later on August 30th, 2023, should have easily been the same. I never met her. Because a father would definitely remember if he had ever met his son's girlfriend who had just been murdered. Conversely, a father would know if he had never met the murdered girlfriend of his son in such a high-profile case. However, if at his February 2017 interview, Holder was not telling the truth as to how many times he met Abby Williams, then it may be difficult for Holder to remember what lie he had told law enforcement 6.5 years earlier when he was re-interviewed. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that he in fact had met Abby Williams one time. Either Brad Holder intentionally lied to the police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby, but somehow magically remembered that meeting 6.5 years later. Then at his May 2nd, 2024 deposition, Brad Holder provided yet a third fucking different answer. That he had actually met Abby Williams 2 times. Furthermore, at his May 2nd, 2024 deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. And those items are the video of his and Logan's interviews, data from his phone, video from his second interview, audio from the second interview, reports, notes, documents, crime scene photo, what appears to be a mimicked crime scene photo from his Facebook, etc. When combined with The evidence contained on Brad Holder's social media pages, including images of a rune inked onto his hand that mimics the way the sticks were formed on Abby's body, as well as other evidence detailed in Frank's 1, as well as the many photos of runes formed with sticks, the ever-changing stories of Brad Holder on the simple topic of how many times did you meet Abby Williams should provide all the insight into why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the many missing items would contain obvious exculpatory evidence. The defense believes that it has shown that the missing destroyed evidence is exculpatory in nature. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find that the missing destroyed evidence is potentially useful and dismiss charges. As detailed in the accompanying memorandum, if this court finds that the missing destroyed evidence is not exculpatory but does find that it is potentially useful, then the court should dismiss charges if it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. Franks 1 through 4 provide many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed or acted in bad faith. The defense incorporates the contents of Franks 1 through 4 into this motion. Provided below are a few facts that support the defense contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. Missing portions of vital video from Jerry Holman's 10/26/22 interrogation of Richard Allen. Jerry Holman interrogated Allen on October 26, 2022, and said interrogation was videotaped. However, the first few minutes of the interrogation are inexplicably missing. Missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights. And freedom to leave the room, both important concepts that might support the legality or illegality of Holman's interrogation. No explanation exists as to why the only portion of the videotaped interrogation that's missing is the crucial beginning of the interrogation. The missing video supports the defense contention that Holman knew he screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed, allegedly because there was no Miranda rights notice or warning. The missing video from Holman's October 26 interrogation of Richard Allen is evidence of the intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. In his August 10, 23 deposition, when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no. However, it's clear from reviewing emails between Doug Carter and FBI Jay Abbott that Brad Holder was a suspect early on in the case. As stated before, Holder was thought to be a suspect, and his name was known as a suspect even at the highest level of the state police, Superintendent Doug Carter, and even known to Indianapolis's top FBI agent, Jay Abbott. The fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. As detailed in Franks 1 and the numerous other pleadings, prosecution chose not to turn over exculpatory evidence from May 1st, 2023 until September 8th, 2023, of a letter from Todd Click and the 85 pages detailing his investigation. Contained in the Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspect Brad Holder, Patrick Westfall, and Elvis Fields were involved in the murders. And Click's beliefs that the evidence supporting their involvement in the murders were much more compelling than the evidence against Richard Allen. As stated in a previous pleading, it's hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers, that's Click, Murphy, and Ferenczi, but essentially believed that the wrong man may have been arrested. The fact that the prosecution refused to not immediately turn over the exculpatory click letter for 4 months is evidence of the intentionality of law enforcement involving concealment of evidence and or evidence of bad faith. Yes, I believe it's a withholding of discovery. As detailed earlier in this motion and in the Franks 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. The prosecutor turned over these videotaped interviews nearly 9 months later than required under the rule and statute. These videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. The fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the murders until after the defense would soon learn of their existence is evidence of the intentionality of law enforcement involving the concealment of evidence and or evidence of bad faith. The matter has been detailed in Franks 1, 2, and 3 and in other various pleadings previously filed of a Purdue professor whose testimony contradicted the sworn statements of Jerry Holman. At his August 10th, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor had ruled out such a possibility. However, after reviewing the Purdue professor's report prepared on March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim, as Jerry Holman stated in his deposition under oath. Furthermore, at his deposition, the Purdue professor, Jeffrey Turco, specifically denied that he had ever made the very statements that Holman had attributed to him. Under oath. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of a Purdue professor, was still unknown and may not ever be able to be found. This was untrue, as Holman had already learned the name Jeffrey Turco weeks earlier. Additionally, the defense learned that the actual report from the Purdue professor from March 1st, 2017, which also contradicted his deposition testimony, was in possession of law enforcement since that very time, but was purportedly rediscovered by law enforcement on August 2023. Prosecution finally produced said report to the defense on October 4, 2023, and only upon specific request of the defense. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of a Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and or evidence of bad faith on the part of law enforcement. A key piece of evidence in this case is the phone data extracted from victim Liberty German's phone. Prosecution and law enforcement had possessed that evidence for 5 fucking years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8, 2023, which is 9 months later than required under criminal rule, which is 30 days. However, the defense did not receive that evidence until September 8, 9 months later. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline. Remember, the phone was turned on at 4:30 in the fucking morning. Explain that one, Troll Farm. Explain it. This does not support law enforcement's timeline and supports that a third-party suspect or suspects were involved in the murders. The failure of law enforcement to turn over Liberty German's phone data for 9 months, thereby concealing exculpatory evidence, the defense could have been exploring from the beginning of their representation of Mr. Allen is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Law enforcement concealed the Blocher report until April 26, 2024. On April 26, 2024, the state of Indiana turned over a report from Steve Mullen. Yes, that's Steve Mullen, who did not investigate Tyler Carpenter's role in the infamous crime scene leaks, concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. Say so. Say so. What do you say to that, Troll Farm? What do you say to that, Jerry Holman? Who turned off Libby's phone? Who turned on her phone? Who turned the phone off? Who turned the phone on? The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over to the defense, and only after the defense sent a certified letter and filed a motion to compel and for sanctions demanding that the prosecutor turn over certain evidence, is further evidence of the intentionality in attempting to conceal evidence and evidence of bad faith. Yes, 1 fucking year. Don't forget it, ladies and gentlemen, the Blocher report of Sergeant Mitch Blocher, detailing the fact that the phone was turned off on the 13th and back on the 14th. Tobe Lesenby contradicted sworn testimony of both Jerry Holman and Tony Liggett concerning the number of people allegedly involved in the murders, and so did Nick McClellan, least we forget. This matter is detailed in Frank's 1. Both Liggett and Holman testified under oath that only one person, and that is Richard Allen, was involved in the murders of the victims. Proclamation under oath by Liggett and Holman would negate the defense's contention that evidence supports multiple people involved in Odinism were involved in the murders. However, when Tobe was deposed, he, Lesenby, stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. And remember Nick McClellan making the statement that he has reason to believe that additional parties may be involved in the murders. This conflicting sworn testimony of law enforcement and the prosecutor is further evidence of intentionality on the part of the law enforcement and prosecutor to conceal their actual beliefs concerning the number of people involved in the murders of the victims in order to direct the defense away from the theories that Odinists or multiple parties were involved in the murders, and additionally evidence of bad faith. And it's an attempt to railroad Richard Allen, make him the lone wolf killer of Abby and Libby, make the case go away forever, and solve the huge problem looming over Delphi. That is that there were several of you in the community that participated in this crime that will be brought to justice, and you don't want it to happen. You want it to go away, and you are going to use Richard Allen to make that happen. Well, let's see if Richard Allen himself allows that to happen. In 2017, Dan Doolin has stated that he, another corrupt official, Dan Doolin, knew that he had audio recorded interviews when conducting interviews of tips or leads. Doolin claims that he now believes that he never recorded his interview of Richard Allen. I think I must not have audio recorded it because all the other ones I had are in a file on my computer. And oops, I listened to each one of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen, according to Doolin's deposition. This interview was crucial as to what Doolin claims Allen told him. Doolin helped establish the timeline used to secure a search warrant and to arrest Allen. And remember, that is the very search warrant on which Tony Liggett lied and misrepresented witness statements in order to obtain the search warrant. The defense believes that Richard Allen was tape recorded and that the missing tape supports intentionality on the part of law enforcement and evidence of bad faith. Missing mimicked crime scene image. This was detailed earlier in the motion and in the Franks 1. The fact that this incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said image, is evidence of intentionality on the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. Brad Holder is a key third-party suspect, yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that support Holder's involvement, along with other third-party evidence of suspects identified in Frank's 1. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. Furthermore, law enforcement claim, apparently, that they never extracted data from Brad Holder's phone when they extracted data from at least 101 other fucking phones from people who weren't even suspects, like Holder was. Furthermore, law enforcement claim, apparently, that they never extracted data from Holder's phone when they extracted data from Logan Holder's phone, which was turned over to police at the exact same time that Holder turned over his phone. Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview, conducted at the Logansport police station, and the defense only learned of said interview through a deposition of Brad Holder conducted on May 2nd, 2024. Furthermore, law enforcement claimed they cannot access the mimic crime scene photo that was on Brad Holder's social media page. All of the issues of missing evidence around one person, Brad Holder, and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of that evidence that the defense does, in fact, possess concerning third-party suspects for 9 fucking months, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect evidence. The bad faith of law enforcement and prosecution have been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over in a timely manner. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. Even if the court finds that the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that the charges against Richard Allen be dismissed. All right. So, what do you do with that? Sorry about that. All right. Jeez. Give me one moment, please. One moment, I'll get the other one up. Okay. This is the memorandum of law. We'll read quickly through this. At issue is the purposeful or negligent failure to preserve and or destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness, later identified as Professor Jeffrey Turco, and other exculpatory evidence such as the Todd Click letter and evidence referred to by Click in his letter. This would include new examples of missing evidence detailed in the motion, filed simultaneously herewith. Indiana Code 35341-4A states that this court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests the court dismiss this information pursuant to Indiana Code 35341-4A, which states that a motion to dismiss an information may be granted for any other ground that is basis for dismissal as a matter of law. Such grounds would include a violation of the defendant's constitutional right to due process. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. A motion to dismiss based upon a ground specified in Indiana Code 3534-1-4A11 may be made or renewed at any time before or during trial. Therefore, this matter is properly and timely raised. The Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of the defense to material evidence in its possession. Read that again, Prof. A serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of the defense to material evidence in its possession. That's the Indiana Supreme Court. It is likewise a serious breach when, through a lack of diligence, the negligent destruction, 70 days plus 1 week, negligent destruction or withholding of material evidence by law enforcement officers or prosecutor occurs. In such instances, ground for reversal may exist. Do you hear that? Do you hear that? Supreme Court, do you hear that? Appeals Court, do you hear that? Prosecution and Judge Gull. The Indiana Supreme Court has also held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on the due process and due course of law grounds. Read that again, Prof. The Supreme Court has also held that negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal. Do you hear that? Prior to any request for discovery by the defendant, the negligent destruction or withholding of material evidence by the police or prosecution may present grounds for reversal. The Indiana Supreme Court has further held that when the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. Let's read that again. This is a very important memorandum that none of you have really latched onto. When the prosecution determines evidence to be non-material, as they've done in this case, and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. The appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was, here's the standard, quote, potentially useful evidence, or, quote, materially exculpatory evidence. The burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant. Potentially useful evidence is defined as, quote, evidentiary material of which no more can be said than that it could have been subjected to tests, the result of which might have exonerated the defendant. Do you hear that? Do you understand why I am saying that the state of Indiana is setting this case up for a successful overturn on appeal? Now, if you really believe Richard Allen is guilty of this crime, is that what you want? Would you want that? The state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. Violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. The bad faith presumption arises when the failure to retain records or other evidence actually violates the term of the applicable policy. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by the officers. Do you understand the incredible appeals court scenario that we are setting up here in Delphi? Material exculpatory evidence, on the other hand, is defined as evidence that possesses, quote, an exculpatory value that was apparent before the evidence was destroyed, and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Yes, that means the first week of interviews and the 70 days of missing investigation. The state's good or bad faith in failing to preserve materially exculpatory evidence is irrelevant. Doesn't matter if it was accidental. Do you get it? The defendant must establish materiality as a condition precedent to claiming a denial of due process, where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or showing of materiality is prevented by the destruction of evidence. Do you get it? Reading that last part again. Or a showing of materiality is prevented by the destruction of evidence. What does that mean, Prof? That you don't have to show materiality because it has been prevented by the destruction of the evidence. Court of Appeals is going to destroy this case. An item is material if it appears that it might benefit from the preparation. An item is material if it appears that it might benefit the preparation of the defendant's case, or if it might reasonably affect the outcome of the trial. Are we picking up what I'm putting down here? Or I should more properly ask, are you picking up what Baldwin and Rozzi are putting down here? In this matter, given the nature of the evidence that law enforcement either failed to preserve or actually destroyed, the materiality was and is self-evident. Furthermore, as in Lee, the failure to preserve or destruction prevents the defense from establishing the exculpatory nature of the evidence and its materiality. Do you see? That's what we just read. The failure to preserve or the destruction of, period, prevents the defense from even establishing the exculpatory nature of the evidence and its materiality. As such, Allen is not required to demonstrate the materiality. Do you understand? To be sure, the unavailable evidence, because it was destroyed, had exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by any other reasonably available means. Yes, because you've got the entire first week of crucially important interviews destroyed. Spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence. If spoliation by a party to a lawsuit is proved, rules of evidence permit the jury to infer that the missing evidence was unfavorable to the party. Even if this court requires a showing of bad faith, it is apparent. Bad faith is defined as being, quote, not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest purpose or moral obliquity. Deviation from moral rectitude or sound thinking is obliquity. The U.S. Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the states to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. The court recognized that same duty in Arizona versus Youngblood, confirming that the Constitution imposes at least a limited obligation on the police to preserve evidence that could form the basis for exonerating the defendant. It is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith of the prosecutor. To prevail on a Brady claim, a defendant establish 1, that the prosecution suppressed evidence, 2, that the evidence was favorable to the defense, and 3, that the evidence was material to an issue at trial. It is clear that the federal Constitution is not the sole guarantor of the rights to due process and other rights. Chief Justice Shepard made this abundantly clear in his law review article, Second Win for the Indiana Bill of Rights, when he stated in the conclusion that civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or Rehnquist Court wishes to make them. The protection of Americans against tyranny requires that the state Supreme Courts and state constitutions be strong centers of authority on the rights of the people. I am determined that the Indiana Constitution and Indiana Supreme Court be strong protectors of those rights. The Chief Justice also stated that Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty. And after citing to numerous early decisions, noted that these were but a few in a line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights which the federal Constitution did not. Chief Justice Shepard also made note of the fact that many provisions of the Indiana Bill of Rights have no counterpoint in the U.S. Constitution, and observed that Article 1, Section 12 was one of those provisions. This provision relating to due process is at issue in the instant case. The Due Process Clause of the U.S. Constitution is found in Section 1 of the 14th Amendment to the Constitution. That section states in relevant part that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law. The right to due process conferred under the Constitution of the State of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. Provision states as follows: all courts shall be open, and every person, for injury done to him in his person, property, or reputation, shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay. While the defense is unaware of Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself was traced back to the Magna Charta in the State Ex Rel Board of County Commissioners versus Larimore. The Larimore Court also acknowledged that the provision was derived from the Magna Charta. It may be a broader that although the provision was derived, it may be a broader guarantee of free, unpurchased, and impartial justice. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from Chief Justice Shepard's concurrence in House versus State that the issue of whether a lack of good faith on part of the state was required for a defendant to obtain a remedy for the destruction of potentially exculpatory evidence under the Indiana Constitution has not been decided adversely to the defendant even after Youngblood. The House decision actually dealt with the discovery of potentially exculpatory evidence and the need for materiality of that evidence. Both Chief Justice Shepard and DeBruler, however, discussed the related issue of destruction of or loss of such evidence. In his concurrence, and Judge DeBruler stated, while I agree with the result reached by the majority opinion on the discovery issue, I point out that when the accused shows that material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution and not the defendant. The police and prosecutors are, after all, highly trained specialists in the gathering and retention of evidence and should be expected to carefully retain all material evidence in useful form. Chief Justice Shepard in his concurrence stated, I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has disposed of arguably material evidence which might exculpate a defendant. The instant case certainly appears to be the type envisioned by these comments. Two Indiana decisions have been found in which the issue of due process and the destruction of evidence was raised under both the federal and Indiana constitutions. Although both of these decisions, Hale versus State and Douglas versus State, were determined adversely to the defendants based on the facts of the cases, both also stated that negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for a reversal. Are you listening? In each case, the defense alleged a violation of due process under both the federal and state constitutions. While both decisions were rendered prior to the U.S. State Supreme Court's decision in Youngblood, supra, the decision in House rendered after the Youngblood decision makes it clear that the principle announced in Hale and Douglas may still be valid under the Indiana Constitution. Additionally, Lee supra was decided after Youngblood. If the language in Article 1, Section 12 of the Indiana Constitution, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, is to have any meaning at all, it certainly seems to support a more stringent enforcement of due process rights than required under federal constitution. Given the facts of the instant case, the penalty involved, and the long history of concern about the preservation of evidence in Indiana case law, as well as the evidence of attempts of law enforcement and the state of Indiana attempting to conceal other material and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence in this case. You think about it. If this was you, would one interview be egregious? Would one 24-hour period of lost investigation be egregious? How about 2 interviews? How about 2 days of investigation? What would you consider egregious if it was you accused of a crime? Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or the prosecution in his case, especially in light of the ease with which the evidence could have been preserved. Remember, in the prior 8 pages, the word negligence came up several times. This loss does not have to be intentional. It does not have to be in bad faith. Negligence applies. Don't you think that negligence applies here? Even if the excuse is that we negligently lost the first 7 days of interviews, we negligently lost 70 days of investigative material. What do you consider egregious? Negligence. All right. Man. All right, guys, I apologize. I'm trying to see. This is called and here's your shucking and jiving. Here's your bullshit response. Now comes the state of Indiana uh, in response to what we just read past hour. Ask the court to deny. There is no basis of law or fact. Well, yes, there is. Well, we just read the basis in law, so we'll ignore that portion, Nick McClellan. There is no further. There is no exculpatory evidence and or potentially useful evidence that the state has not turned over or is missing that the state has destroyed. In whose interpretation, Nick McClellan? Finally, Brad Holder is not a third-party suspect, and there is no evidence tying Brad Holder to the murder of the victims in this case. In your opinion, Nick McClellan? In support of objection, the state would ask the court to consider that 1, the law is clear. A dismissal of charges due to the state destroying or losing evidence is only permitted when the evidence is materially exculpatory or when the evidence is deemed potentially useful to the defense and the destruction of evidence was done in bad faith. No, it's not. We just read the memorandum of law outlining that negligence applies. The defense has not alleged any example of missing or lost evidence that is materially exculpatory or potentially useful in the case against Richard Allen, nor has the defense cited any example of the state acting in bad faith in destroying any kind of potentially useful evidence. Yes, it has. You see the arguing going on? You see, how is a judge supposed to weigh these two things. That exculpatory evidence is defined as evidence that tends to establish a criminal defendant's innocence. Evidence is exculpatory if it clears or tends to clear the defendant from the alleged fault or guilt. For the destruction of materially exculpatory evidence to support a dismissal, the materially exculpatory evidence must be evidence that possesses an exculpatory value that was apparent before the evidence was destroyed, and must be of such a nature that the defendant would be unable to obtain comparable evidence by any other reasonably available means. Well, yes. How would he obtain the first missing week of interviews? That for evidence to be potentially useful evidence, it must be evidentiary material of which no more can be said than it could have been subjected to test, the result of which might have exonerated the defendant. Yes, that was also quoted in the prior document we just read. To be subject to a dismissal, law enforcement must have destroyed that potentially useful evidence in bad faith. No, that negligence applies. I mean, come on, we just read. You see how he's only choosing the bad faith exceptions here, or examples? Bad faith is defined as failing to preserve evidence pursuant to a conscious doing of wrong because of a dishonest purpose or moral obliquity. The defense identified 3 items of evidence that they allege were destroyed or missing, which support a dismissal, including Brad Holder's phone extraction, all evidence of Brad Holder's second interview with law enforcement, and a mimicked crime scene photo found on Brad Holder's social media. They claim that these things are exculpatory or potentially useful and were destroyed by law enforcement in bad faith or through negligence. Come on, stop ignoring that word. In regard to Brad Holder's phone extraction, there is no reliable evidence that the state ever extracted data from the phone. Yes, we know that doesn't exist. The defense in their motion report indicated that Holder was pretty sure he turned over his phone to the police. In addition to saying that he was pretty sure, Holder went on to say, "I'm not going to say that positively, but I'm pretty sure they took my phone. They took my son's and my phone." The state believes Holder is referring to February 17, 2017, where he and his son were both interviewed at the Delphi Police Department. On at least 2 occasions in the deposition, Holder states that the police took both his phone and his son's phone, while father and son were in the lobby of the police station on the day they were questioned by police. When asked how he knew the police took Logan's phone, Holder said, "I'm pretty sure they did it right there in the lobby. I'm pretty sure they took both of our phones. Don't quote me on that because that was a long time ago." However, as documented in records previously provided in discovery, ISP Sergeant Brian Booner collected Logan Holder's phone at Logansport High School on February 14, 2017. Logan's mother signed the consent to search form as a parent of Logan. Brad Holder was not present. Sergeant Booner traveled to Logansport High School and initiated contact with Logan and his mother prior to the victim's bodies being recovered in hopes data on the phone may assist the police in locating the victims. Brad Holder's account of the police taking his phone is unreliable since Logan Holder's phone was seized 3 days earlier, not as Holder insisted, contemporaneous with the taking of Brad Holder's phone. Brad Holder never said the police maintained possession of his phone or extracted data from it. The state is aware of no evidence that police extracted data from Brad Holder's phone or ever had possession of it. Therefore, there's no evidence that the police destroyed or lost Brad Holder's phone extraction. Okay, so we'll just skip the rest because there's no argument at this point about the phone extraction because it's now known that the phone extraction was not performed. Despite the defense's claims, there is no evidence, either physical evidence or witness statements, that connect Brad Holder to the murders or the crime scene. Yes, but there's Brad Holder's statement, according to Amber Holder, implicating Patrick Westphal. And we know that Patrick Westphal is likewise pointing the finger at Brad Holder. Go back, watch Sleuth Intuition's videos. So we have Amber Holder pointing the finger, or alleging that Brad Holder's pointing the finger at Patrick Westphal, and then we have Patrick Westphal pointing the finger back at Brad Holder. That's your nexus. The defense is relying on pure speculation. No. That's not speculation. That's obvious. It's Amber Holder's words about her recollection of conversations with Brad Holder, and it's Patrick Westfall's words to sleuth intuition. In regards to a second interview of Brad Holder done by law enforcement, in his deposition, Brad Holder stated that sometime, he believed maybe a year or two after his first interview, he was interviewed at the Logan Sport PD by two ISP officers, a man and a woman. The state was unaware of any such interview. In the weeks following the deposition, the state has made efforts to determine if an interview of Brad Holder occurred at Logan Sport PD. Recently, ISP Detective Roland Purdy reported to investigator Steve Mullen that he and Detective Lori Lemler interviewed Brad Holder in the fall of 2017 at the Logansport PD. Detective Purdy stated that he had learned that Holder had previously been interviewed and the investigation had ruled him out as a suspect. He said that he and Detective Lemler met with Brad Holder to learn more about what he knew about Odinism. Detective Purdy said the interview was not recorded, nor was a formal report written. There's no support for the argument that evidence related to Brad Holder's interview at the Logansport PD was destroyed or lost. Neither is there any evidence that the Holder interview at the Logansport PD resulted in any potentially useful evidence, much less materially exculpatory evidence. Finally, the defense claimed a key piece of evidence is missing, an image purportedly from Brad Holder's social media that mimics the crime scene. However, the defense not only acknowledged in their motion to dismiss that the image in their possession, but that they showed it to multiple police officers in depositions, which the officers identified as confirming or coming from Brad Holder's social media. Therefore, the defense is arguing that the charges should be dismissed based upon the destruction or loss of evidence the defense currently possesses. There's no case law supporting such an argument. As stated in Chazelle versus State, materially exculpatory evidence is that evidence which, quote, possesses an exculpatory value that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Yes, we're talking about the first week of interviews. That none of this evidence that the defense says is missing and or destroyed is exculpatory evidence for the case against Richard Allen. Brad Holder is not a third-party suspect. There's no evidence that ties him to the murder victims in the case, according to your opinion, Nick McClellan. The evidence ties Richard Allen to the murder of the victims in this case. The state did not destroy or lose evidence purposely in bad faith. Well, negligence also counts. We just read the document, sir. The motion to dismiss is replete with unfounded allegations and distorted and misinterpreted facts. The defense makes allegations that are not true and not supported by any evidence whatsoever. The state response to the following are false allegations are as follows. The fact that Brad Holder gave different answers how many times he met Abby Williams does not somehow make items A through H exculpatory. There is no evidence to support the rune on Brad Holder's hand mimics the sticks found on Abby. Yes, there is. We've seen it. Further, there is no evidence to support the facts outlined in the first Frank's motion. Yes, there is. We've seen it. There's no portion of the October 26, 2022 interview of the defendant missing. The defense has been provided with the entire recording. Yes, which cuts off after it had started. So there's no record of any Miranda. So was there Miranda or not? Lieutenant Jerry Holman did not lie in his August 10th, 2023 deposition when he answered the question, was Brad Holder a suspect, with not really no. Lieutenant Holman went on to state on the following page that Brad Holder wasn't really a suspect because the police had encountered him through Holder's son, who was a friend of the victims, and was interviewed, and the investigation revealed he was not at work. He was at work at time of the murders, but that has changed. We know now that he actually, if he ever was at work, he got out at 2:45 p.m. Not only that, we also know that he was considered a suspect due to the emails between Doug Carter and Jay Abbott. That the state has turned over to the defense the Todd Click letter and related reports and interviews after the state became aware that said items had not been previously provided. The state did not intentionally delay in providing the information to the defense, nor did the state intentionally conceal any evidence in this case. How do you know that? How do you prove that? because the defense can prove that you delayed for 9 months in turning that over and only turned it over after you became aware that they were aware of it. So how do you prove that you were not aware of it and that you did not intentionally delay in providing it? So you see, and remembering that according to precedent, the burden or the losses must be taken by the state, not the defendant, in cases such as this. F, the state did not attempt to conceal the identity of a Purdue professor, nor does his testimony contradict the testimony of Lieutenant Holman. This professor, Dr. Turco, has stated under oath that it is the defense who has mischaracterized his testimony rather than Lieutenant Holman. Oh, yes, but it's proved with a timeline that the state did know the identity of the professor at the time that the state reiterated that it did not have the identity of the professor and alleged that the state might not ever know the identity of the professor, when in fact the state did indeed know the identity of Professor Turco. So this is a twisting. The state did not intentionally delay providing the extraction data from Liberty German's phone, nor did the state conceal exculpatory evidence from said phone. Then how do you excuse waiting a year to turn that phone dump over? How do you, if you did not intentionally delay providing the extraction data from Liberty's cell phone, then how do you explain waiting a year to turn it over? The state did not conceal a report involving documented communications between Carroll County prosecutor investigator Steve Mullen and ISP Trooper Blosher, nor is the information in the communication in any way exculpatory or even potentially useful. Are you kidding me? That the defense's conclusion that 6.5 years after a complex criminal investigation began, officers had different recollections of what other officers believed during the investigation is somehow proof of a conspiracy to conceal officers' actual beliefs is very strange. The state does not know how that would be exculpatory, even potentially useful in the prosecution of Richard Allen for murder, because the question is, are we dealing with a lone wolf or more than one? You seem to sidestep that major issue, the elephant in the room in the Delphi murders case against Richard Allen. Are we dealing with a lone wolf killer, or are we dealing with more than one? That's why it's important. It's important because not only did law enforcement believe there was more than one, we have current law enforcement who believes it's more than one, and there has been a prior instance in which Nick McClellan himself insinuated or stated that it was possibly more than one. So the question is, do we have more than one, or do we only have one? And why is there even any discussion about it? The Department of Natural Resources officer Dan Doolin testified that he prepared a written report of his interview of the defendant, but could not locate any evidence that he had recorded his interview of the defendant, and therefore believes he did not record it. However, he testified that he prepared his written report very soon after his interview and would have no reason to destroy the recording. Yes, but he also testified that he records everything. So why not this one? That the image the defense believe is a mimicked crime scene image is not missing. The defense is in possession of the image. No. That's another twisting of the facts. The fact is that it's missing from discovery because you did not hand that image over. So it is missing from discovery. That Brad Holder is a key third-party suspect is false. Again, there is no evidence tying Brad Holder to the crime. The defense cannot meet its burden even to allege that he is a third-party suspect, but he was a suspect. Okay, so do you see how I say that it's so infuriating what we're dealing with here, especially when we're dealing with a judge who has exhibited obvious bias? Okay, so something stinks here. But there you have it. There you have it. That is all. That covers everything that we needed to cover to understand a little more about what has transpired in the past few days, um, what is now being taken under advisement by the judge, meaning that she has to now take all of this shitstorm and go do some hand wringing over it and figure out how she's going to manipulate these various arguments and disclosures to benefit best the state and her own self and her friends, because we don't expect the bias to go away. So she's going to go figure out how to deal with all of this, and we'll find out. We'll find out in the coming weeks what judgments and decisions she makes, and we know there are some very major decisions, especially concerning the uh, the things that are going to be allowed in the trial. This is basically, we're talking about evidentiary issues. Okay, we're talking about what is going to be allowed in front of that jury. Is it going to be a are we going to muzzle the defense so that they cannot mention the word Tony Klein, Keegan Klein, Ron Logan, Brad Holder, Odinism, sacrifice? Is that the route we're going to take? Are we going to allow the defense to present their defense? Are we going to allow them to open some cans of worms that these people desperately want to keep closed? As I mentioned, when you people are running around here watching the various opinions on the things that are transpiring, keep in mind that people will make of things what they wish to make. So people are going to run with box cutters and discussing the fact that you can purchase serrated blades. People are going to run with uh, a victim was walking around in her own blood and her hand touched a tree. People are going to run with this victim was laying down and bled in a manner that the blood flowed in a particular direction, and people are going to run with so many fucked up opinions upon basic nuggets of truth that have dripped out. And I just don't know what to tell you, because the problem is there's far too many here pushing a particular narrative. And actually, they're both extremes because you have people pushing a narrative on one side, people pushing a narrative on another side, and both these are extreme narratives. And I guarantee you, the truth lies somewhere in the middle. And if you care about these victims of this murder, you would care about the truth coming to light because that is true justice for Abby Gail Williams and Liberty German. And the truth will be stranger than fiction. It always is. The truth will be horrible. It has to be. And I guarantee you, the parties that are on the extremes of both sides are not giving you the truth. Okay? So, my suggestion is to pray because we know that these people are Satanists. We know they practice dark black magic. I know that for certain. I have confirmed it. These people are doing their spiritual warfare. So I ask you this. Put on your armor of God. Pray. Pray for justice in this case. Pray for everyone in this case. And pray for yourself because we know that far too many people following this case are suffering from mental illnesses. And it's very apparent in navigating this community. So become prayer warriors. Okay? Get on your knees and pray to God Almighty that He does the right thing and He brings about truth for the murders and murderers of Abigail Williams and Liberty German. Because no matter who goes away or doesn't, I don't care about that whatsoever. I care about truth coming to light in the Delphi murders of Abigail Williams and Liberty German, because that is true justice. And that is truly honoring their memories, which is all I care about. So God bless you all for being here. God bless you for sticking around in this 7 years of gaslighting and bullshit, because it's a damn shame that so much chaos and so many bodies have come behind these murders of Abigail Williams and Liberty German. It's been a manifestation of evil because the first domino was a manifestation of evil. And the only way we're going to defeat that is with prayer. And when you're praying, I ask you to go in, to turn it inwards, and ask yourself, what would God, or ask God, what do you want me to do? Will you heal me from this community? And will you align me in the right direction for this community? Because this has been horrible, and it is horrible. And there's only one answer, and that's prayer. Okay, so I thank you all. I love you all. Thank you so much for being here. We will do a less serious Friday night show tonight, hopefully, and where we're able to unwind. And hopefully after these 3 days of heartbreak and intensity, everyone can kind of unwind a bit and maybe let the chaos down. I mean, everyone's been so insane over this, and in their struggles to be right, in their struggles to cover their own asses, and their struggles to fight back the evil, and all of the various sides. Maybe after this time, from now until October, we can have a little intermission where everyone has some happiness, some peace of mind, because it's needed. And I'm going to do so myself, but I'm going to do so in an unconventional manner, and you're going to see. Okay, you're going to see what that is in the coming weeks prior to the trial, if and when the trial happens. But let me look at some of your comments here. You've provided comprehensive legally comments and insight. Well, thank you, Marianne Foster. Thanks for being here. But he glared at the families and court TV reporter. It's so fucking fake, and somebody's paying these, like Paulatan and Nancy Grace. Yes, others have been paid, and we have proof of it. And all of that truth will come to light. I mean, truth about the leaks will come to light. The truth about the obituary will come to light. The truth about the troll farm will come to light. All truth will come to light. And the truth about the murderers of Abigail Williams, Liberty German, will come to light. And the murders, if they're not murderers. Hello, Old Mort. Box cutters, yes, it's so much to catch up on. I truly care about Abby and Libby, what in the hell happened to them, and how no more children suffer. Thank you, Omar. How Abbott was on board. Is there an investigation of law enforcement? Yes. What is the FBI doing? Because we know we have a corrupt FBI. Okay, let's back it up. Thank you, Lisa. Thank you. Yeah, we know we have a corrupt FBI. I mean, just look at Christopher Wray. No bullet hit Trump. It could have been shrapnel. I mean, come on. We know we have a corrupt FBI. We've had a corrupt FBI for years. So is the corrupt FBI following this case and the various parties? I don't know. What's up, Diamond Eyes? God bless you, Marion Foster. Hey, thank you, Diamond Eyes. Pray for the protection of the people who are speaking up, especially pray for Four Pits, because he's the only person I know of that speaks truth who's from the area. Yeah. And you know what they do to him? They mock, harass, disparage. Yeah, you guys just pray for everything. Pray for love. All right. So, yes, love your kids, love your wife, hug your kids, hug your wife. And anyway, like I said, hopefully we're done with the serious stuff for a while and everyone can relax a bit and enjoy each other, because look, that's who we're here for, is each other. What else is there to live for but each other? Because with all the material goods, with all of reality, when you're dead and gone, all you're lacking is each other. And that's what we have to live for, is each other. So enjoy each other. Try to be happy. And try to do better. But I love you guys. Peace out. We'll see you later.